Welcome to Bruce Hurwitz Presents Meet the Experts. I'm your host, Bruce Hurwitz of Hurwitz Strategic Staffing. You can find us on the web at hsstaffing.com. I hope you'll consider us for all your staffing, career counseling, and professional writing needs. I am delighted to be joined today by Howard Matalon. We will be discussing the ramifications of the recent Supreme Court Scroff decision on the concept of reasonable accommodations. Meet the Experts is sponsored by P&K CPAs. P&K is a full-service accounting firm. They provide accounting and consulting services to businesses ranging from startups to small and mid-cap companies to nonprofits, as well as high-net-worth individuals. Contact them today for a free consultation at info@pk-cpas.com or call them at 973-882-8810. They will be happy to be of service. Howard, welcome to the program.
Thank you. I'm delighted to be here, Bruce.
And I'm delighted to have you here. Please take a minute or two and introduce yourself to our viewers.
So for those who don't know me, my name again, Howard Matalon. I'm an equity partner at OlenderFeldman, and I specialize in employment law. I have a 360 practice where I do both the management side and the employee side. I've been practicing in the area of the employee side as well for about 12 of my 32 years. And I also have an HR background, which kind of fleshes or rounds out things. As my bio suggests, we're also in the process of launching a brand new business in the executive coaching space, which is really exciting, as I think it's going to help a lot of people. And it's more in your area, Bruce, to talk about career coaching and what's most important to people. Not so much the lawyers, more about the coaches.
All right. Now, the last couple of weeks, the Supreme Court's come up with a number of decisions, some of which have not been exactly acclaimed by some segments of the population. All 6-3 decisions, except for this one, which was Gerald Groff against the Postmaster General. This was a 9-0 unanimous decision, which got absolutely no coverage at all. The one unanimous decision, and it's basically ignored. And from my perspective, the most important. So, as I already cleared with you, so our viewers don't think that I'm being rude, I'm going to read a few highlights of the decision. And I quote, and this was written by Justice Alito. Again, unanimous decision. Title VII of the Civil Rights Act of 1964 requires employers to accommodate the religious practice of their employees unless doing so would impose an, quote, undue hardship on the conduct of the employer's business. Based on a line in the court's decision in Trans World Airlines, Inc. versus Hardison back in 1977, many lower courts, including the Third Circuit, have interpreted, quote, undue hardship to mean any effort or cost that is, quote, more than de minimis, which I looked up and means something minimal or trivial. In this case, however, both parties agree that the de minimis reading of Hardison is a mistake. With the benefit of thorough briefing and oral argument, we today clarify what Title VII requires. We hold that showing, quote, more than a de minimis cost, as that phrase is used in common parlance, does not suffice to establish, quote, undue hardship under Title VII. We therefore, like the parties, understand Hardison to mean that, quote, undue hardship is shown when a burden is substantial in the overall context of an employer's business. So even if Title VII said only that an employer need not be made to suffer a quote hardship. An employer could not escape liability simply by showing that accommodation would impose some sort of additional costs. Those costs would have to rise to the level of hardship, and adding the modifier, quote, undue, means that the requisite burden, privation, or adversity must rise to an, quote, excessive or, quote, unjustifiable level. End of recital. What does this mean?
What it means is that for the first time in 50 years, the court is coming to grips with the fact, in my judgment, that undue burden could never be de minimis because the word undue is in there and that Congress intended it to be more than de minimis. So the court had to go back at some point, and the bright minds prevailed and said, undue burden has to be of a higher standard. Now, what's interesting is this, what we'll call substantial test, is very different from the disability discrimination accommodation test, which actually requires, in order for you to overcome a request for disability accommodation, you have to show that it is significant and disruptive to the business. We're not there yet. That's the standard that the plaintiff and some of the groups that provided amicus briefs wanted the Supreme Court to adopt, and then create basically a uniform or unified standard as to what undue burden is. That did not happen here. So we now have what I'll call this hybrid level, where it is more than de minimis, but less than what we're calling significant or disruptive, somewhere in between.
Well, in this case, we've got a religious Christian working for the post office, who we all know now delivers packages for Amazon on Sundays. He said he could not do that because of his religious beliefs. It wasn't because of a physical disability. It wasn't because of any other
No,
protected class.
that's right.
My religion prevents me from working on my Sabbath, which is Saturday. If he was Jewish, it would have been, it was Sunday. If he was Jewish, it would have been Saturday. If he was Muslim, it would have been Friday.
Yep. It's the first time that we're actually seeing teeth put into the undue burden or undue hardship test for religious accommodations. And like I said, the interesting thing is we rarely have seen, as employment attorneys, religious accommodation requests. We see every day disability requests. The last time that religious accommodation requests ever really had any kind of press value was during COVID because of the vaccine requirements. And many employees were actually seeking an exemption to the vaccine based upon their religious beliefs. It is very likely that, given the court's, let's call it the elevated standard or hybrid standard, that we're going to see many more religious accommodation requests come through, and it will catch a lot of employers off guard because they've never experienced it, they've never seen it before, but they're coming. And the Supreme Court has decided that it needed to finally put teeth into the requirements so that employees will be in a better position now more than ever to actually get the religious accommodations that they may need.
But don't they have to prove that it would be a financial burden on the employer?
No, well, here's the thing. This is a case of first impression. The case was remanded back to the court to evaluate whether and to what extent the burden that the plaintiff would be imposing on the other 6 employees that worked with him would rise to the level of this new undue burden standard. So all we've done is clarify the standard. This is not an overruling of the prior precedent. But what will really be interesting is, how does that district court, the trial court, decide now whether and to what extent imposing this burden on the other 6 employees to pick up the slack or other impact on the business rises to the level of an undue burden. We don't know yet. We don't know.
The Third Circuit is the one that makes the decision.
The district court makes the trial court makes a decision. The Third Circuit was the Court of Appeals, interim Court of Appeals, and then you have the U.S. Supreme Court, which obviously is the highest court in the land, both reviewing every other decision.
It goes back to the original court.
Correct.
They make their decision. And if somebody doesn't like it, meaning either Mr. Groff or the Postmaster General, it goes back to the Supreme Court.
It will go back to the Third Circuit, and then the Supreme Court could review it. But it is extraordinarily rare to have the U.S. Supreme Court ever sit in the same case again. Most likely, this will be handled decisively by the Third Circuit if the district court rules in the plaintiff's favor. We know that U.S. Postal Service will appeal it.
What precedent is this setting? If somebody has a disability, any of the protected classes, does it have any impact on them?
It won't have any impact on any protected classification other than religion. It was the one area of Title VII that needed some kind of clarification, but that the Supreme Court hadn't touched. Disability accommodations are very well settled in the United States now, and has the highest level of requirement for the employer to show that it would be effectively disruptive or financially impactful. There's no requirement under Groff that it be financially impactful, just that it be significant. What does significant mean? Well, there's going to have to be an assessment now as to how asking this one person not to work on Sundays, for example, harms the business interests of the U.S. Postal Service. It could have very significant impact, because we're not just thinking about this gentleman, but we have to think about all the other Judeo-Christians or Muslims or those who respect a certain religious belief that come out and say, I cannot work on X day because of my deeply held religious belief, and other people will have to work. Is it impactful? Maybe. Is the burden going to be shared disproportionately with other workers who would have to work on those days? Maybe. You could imagine all kinds of other potential issues coming across. Let's say you are Jewish and you are of a faith that believes in the laws of kashrut, kosher laws, and there's a cafeteria that doesn't have kosher or isn't keeping kosher, and someone says it offends my religious sensibilities, so I will not sit in the lunchroom between 12 and 1. It'd be hard for the employer to say that the individual not sitting in the lunchroom would impose an undue burden, right? So it remains to be seen with this new standard, which is a brand new standard for religious accommodation, 2 things. One, how many more individuals are going to come out and complain that their religious beliefs are being violated, and what kind of accommodations are necessary? The great thing about this Groff case is it involves probably the burden that the employer is most concerned about, Bruce, which is, I'm not working today. Of all the things that an employee can complain about, I'm not working is the one that gets the most attention, right? Correct. Because of the fact that it is disruptive to the workforce. And I'm sure one of the arguments that the U.S. Postal Service is going to employ is that if, in fact, the de minimis standard is now been heightened, and I have a bunch of Judeo-Christians or Muslims working for me, and everyone wants an extra day out, how do we handle that? How are we going to manage a workforce? It may be that the U.S. Postal Service says, you know what? We're just going to have to muddy on through. You know, it's not as if every religious group believes that Sundays per se are a day to take off, right? As you so wisely put. So we have to now look at how an employer will handle a number of employees saying that there is some aspect of the job that they are refusing to do or cannot do, when remember, accommodations are usually trying to make some kind of resolution or adjustment. This case was the most powerful one of all, where they said the only accommodation that will work is this person not working at all.
Well, there's one thing I have to disagree with you about, and I'm sure the Supreme Court would unanimously agree with me that as far as dietary laws are concerned, not providing a Jewish employee with a kosher pastrami sandwich would be cruel and unusual punishment, and therefore
yes, that is true. And actually, kosher deli is much better. But I'm not going to get into that. That could be its own discussion. But I do like me a good kosher deli.
Now, my serious question is, what if they knew it when they hired the person? The person came in, they were wearing a yarmulke. They knew that the person was an Orthodox Jew, not working late on Fridays, not working on the Sabbath, not working on holidays. Same thing for a Christian or a Muslim. They made it clear up front, and they got hired. Can they then go back and say to the employer, look, we knew that your religious beliefs prevented you from working, and we really believed we wouldn't have to ask you to do this, but because, to use this, Amazon, we've now signed a multi-million-dollar deal with Amazon. We need all hands on deck.
Yeah, well, in any case in which an employee discloses an issue, and remember, this is the employee's disclosure obligation, right? It's not for the employer to suss out what someone might need. So if a Jewish employee at a 7-day-a-week business, where it was critical for that person to be working, were to say, I love this job, but I can only work 6 of 7 days, depending upon what the job is, the employer may have a right to say, I'm not going to hire you because it is critical. So let's say, for example, it is an Orthodox Jew who is working, let's say, not say the U.S. Post Service. Let's say they are working as a security monitor. Their job is to sit in front of cameras every day, 7 days a week. They say, I can't work on Saturday. The employer doesn't hire them, and they sue the employer for a failure to hire, right? Same thing, you didn't make an accommodation. Based upon the nature of the job, the employer might be able to say, and they probably would win, I need you there 7 days. I'm hiring you expressly on a 7-day basis. And if there's someone else that I can hire that doesn't have this issue, I'm going to hire them because this is critical. Now, if you have 10 security people, it's a very different story, right? This is going to affect businesses very disproportionately. It has always been the case that the smaller the business, the easier it is to establish the undue hardship, right? If UPS was only 7 employees as opposed to however many tens of thousands they have, this case may have been handled very differently, right? So we always have to remember that you need to look at the circumstances of the employer always to determine whether or not this is a problem. So the smaller the company, the more likely that they can establish an undue burden easier, depending upon what that burden is.
Now, the example that I always used was that if someone is in a wheelchair and they can't get into the building, putting in a ramp is not a big deal.
In fact, it's required.
However, if they've got to go up to the 6th floor and or not the 6th floor, the 3rd floor, the 2nd floor, and there's no way to put in an elevator, then the employer doesn't have to do that.
Well, I think what would happen in that situation is the accommodation would be that unless it would be burdensome to put that person on the first floor, the employer is going to have to show why it wouldn't be reasonable. Why can't
And
they
the
be
first floor is a lobby and it's shared by multiple
right? If
businesses,
yeah,
no
if
privacy.
if we eliminate the possibility that the employee could be housed on a different floor, I would agree with you that the employer has a good chance of proving that that is a burden it can't make. It's an old building. It can't support an elevator. There's no way to get that wheelchair up to the 6th floor. Yes, I do think that the employer would have a very good possibility of showing that this employee, despite their disability, cannot be accommodated because it would be an impossible burden for the company to meet. Now, there would also be the question, of course, as to whether that employee would say, that's fine, I can work remotely,
That's true.
right?
That's
I
true.
don't need to be in your building. And what's fascinating about the area of accommodation is you have to look at the business as it exists today in the modern era. If I have a business where everyone is in the office and there's no remote working, it's one thing. If I have a business scattered around the country, then insisting that this one poor individual who needs a wheelchair and needs to come to work every day, that's going to be a problem. That actually may not be as much a disability accommodation problem as a disability discrimination problem.
Well,
Right.
I had one that I had to deal with, not as a lawyer. I always make it clear I'm not a lawyer. I'm not giving legal advice. My client, the employer, was in a landmark building. And they simply couldn't get permission to change a doorknob, let alone put it in an elevator. In any case, in any event, the closest thing that I can think of to the Groff case would be someone who has a mental health disability. So they're protected because it's a protected class. And let's just say that they needed every day to be on the phone with their therapist for 20 minutes to a half hour. All fine and good, no problem. Everybody knows it. Nobody cares, doesn't interfere. But now, because of a deal with an Amazon, they need that person to be in the office. I'm sorry, to be out of the office. So they don't have the ability to have a private conversation with their therapist. Is there anything to that analogy?
Well,
or is there another analogy that you can give?
well, that's what's so interesting about this case, because the court has now created a different standard that is not basically that I can walk across this line standard, which is really what de minimis is. And yet it's not a standard of really requiring a serious or significant financial impact or disruption to the business. So what does this intermediate step really look like? It may be that how this is going to work is that employers are going to look at the standard for disability discrimination and figure if it's one step removed from that, it may or may not be an easier standard for them to make. I don't know. It's going to be fascinating to watch and see as to how this standard is different. And it is still a really interesting question why the court did not adopt the higher level standard, right? It is now, again, created an artificial distinction between someone with a disability and someone with a deeply held religious belief. Well, that's interesting because what is the basis under which a belief should be held different than a disability? Right? And that's going to be the haunting question here. I personally thought the court would adopt the same standards. But the court has decided that Title VII and the Americans with Disabilities Act are on different levels. Very interesting. Of course, different Congresses when they were both passed. So where this goes, civil rights versus disability, right? That's what Title VII is. It's a Civil Rights Act.
Mhm.
Why the court decided that civil rights are not entitled to the same level of protection as what you would call a physical or mental health issue, right? When they're all individual rights. In fact, I could say one thing, almost everything has become disability, right?
Oh, sure.
If your headache is diagnosed as chronic migraines, you have a disability, right? If you have long COVID, it may ultimately be classified as a disability. Obesity is a disability. Alcoholism can be a disability, right? So we're almost at the point where, talk about a protected class, the average age of the American is 40 or older. And so we're all in a protected class one way or another, right? But there are obviously different standards or different issues that the US Supreme Court is considering when it's deciding the difference between civil rights and rights that pertain to physical or mental health. Perhaps it's because that is an issue that is not really within your control.
Any idea about why this one was unanimous?
No idea. It's one of the most fascinating things because we rarely see unanimous decisions from the court at all, let alone over something like free speech, religious accommodations, right? But perhaps what this is telling us is that all of the justices believe equally in the freedom of speech and believe that the First Amendment is sacred. That's all that I can gather from that. But I'd have to look back at all the precedent on First Amendment, and I guarantee you they're not all unanimous. So what made this special? Very good question.
Howard, I want to thank you. I'm going to put up your contact information. And final question, is there anything that I didn't ask you which you wish I had? And if I had asked it, what would you have said?
Well, you could have asked me and I would have genuinely be curious, like, where's the best place to get that kosher deli sandwich? But no, I think you beautifully captured the issue. I do think that it's going to be very important for employers to think this through. I will tell you that in my experience, novel issues are usually treated poorly by inexperienced employers. So the best advice I could give those who are watching this is to say, please consult with someone who understands how these accommodations operate before you decide whether to grant or not to grant them, because every decision you make can create precedent for your business.
And can cause you to wind up in court.
Can cause you to wind up in court. That's right.
Howard, thank you very much for coming on. I appreciate it. You've given a lot of insights, which I know our viewers will appreciate.
I'm grateful for the opportunity. Thank you, Bruce.
Thank you all for watching. I'm Bruce Hurwitz, and as always, please stay focused on success.